The Royal Commission into Defence and Veterans Society is now in session. Please be seated.
Thank you. Good morning, Ms. Longbottom. Can you hear us okay? Just checking.
I can, thank you, Commissioner. I'm here with Ms. Molyneux as counsel assisting.
Thank you. And counsel for the Commonwealth?
If the Commission pleases, I'm here with Ms. Brancar for the Commonwealth. If you don't mind, I'm going to start seated because otherwise I think I'll be out of the screen.
No worries. Thank you, Ms. Moore. Thank you. Ms. Longbottom?
Cardis, may I commence by attending to the tender of a number of documents? Can the operator please display the tender list? Commissioners, we seek to tender documents numbered 40, 41 and 57 in the manner in which they are described in the list. The balance of documents we simply ask be marked for identification.
Thank you. They'll be accepted on that basis then and allocated the next lot of consecutive numbers. Thank you.
Thank you, Commissioner. Commissioners, the topics for the procedural hearing are conveniently set out in an aid memoir that has been provided to you and the Commonwealth. Before dealing with those matters, however, there is a threshold issue raised in the Commonwealth's correspondence with respect to the power of the Royal Commission to issue directions that we consider it appropriate to canvass at the outset. The purpose of canvassing is to seek clarity about the Commonwealth's position and whether or not they put in issue the power of the Royal Commission rather to issue directions. In terms of developing that issue, can I ask, please, that document number 1 in the tender bundle be displayed? It's DVS.0010.0001.0007. Commissioners, that is a letter the Royal Commission sent on the 6th of June indicating the intent to hold the procedural hearing and foreshadowing the nature of the issues and directions that may be sought with respect to a series of topics. Materially, if we can please turn to pages 2 and page 2 of the document at first instance. You will see in relation to what there is identified as topic PH2, on the following page, page 3, we sought an affidavit with respect to that topic. And then if we can then please turn to page 4, in relation to topic PH6, an affidavit was also sought. Operator, if you could then please display document number 2 in the tender bundle. It's DVS.0010.0001.0011. This is a response we received from the Commonwealth on the 16th of June 2023. Can I ask that paragraph 1 and paragraph 3 of that document on the first page be highlighted? So you'll see there, Commissioners, the Commonwealth expressed the desire to continue to provide substantive support to the Royal Commission as it continues its important work, and similarly acknowledge the vital work of the Royal Commission, both of which are sentiments we are grateful for. But if you can then please turn, operator, to the next page and highlight subparagraph 7B. You will see there, Commissioners, in relation to those 2 topics in respect of which we sought affidavits in our letter of 6 June, the Commonwealth there raises the question materially of the Royal Commission's power to compel production of evidence as proposed in our letter. Now, we just pause to observe that it is somewhat disconcerting that despite the Commonwealth's protestation of providing substantive support to the Royal Commission in relation to its vital work, that at least in this letter, and I'll take you to some subsequent correspondence, the Commonwealth declined to provide the affidavits that we'd asked for and put in issue the compulsive powers of the Royal Commission with respect to matters of procedures. So that is a threshold issue. We say it will be apt for you to seek clarification from the Commonwealth about. We should note that in more recent correspondence on the 23rd of June, we understand that there has been some shift in position, at least in relation to provisionally agreeing to provide certain material on affidavit or statements rather. But in our submission, this is a threshold issue about which we need clarification from the Commonwealth. I'm in your hands, Commissioner, but this might be an apt time to seek their response, given that it may affect the directions that we're ultimately seeking.
Yeah, Commissioner Douglas will deal with these issues.
Ms. Maud, are you in a position now to address that issue?
Yes, Commissioner, I can deal with it specifically by reference to the directions. The position now is that we don't oppose providing a statement with in relation to Captain Francis's statement, the dates that information was advised within the Commonwealth team, which resulted in the provision of the supplementary statement, and nor do we oppose the direction in relation to the provision of the signed statement. So in my submission, it's not appropriate to deal in a general way about the Commonwealth's position. The power to compel production of information obviously turns on questions of relevance, and that requires a case-by-case assessment in each case. So with respect, it's not useful to deal with it at a general level. And the issue has largely fallen away for the purpose of today because the Commonwealth is content to provide the information that's sought in the relevant directions.
So that's in effect a concession to Order 1A, is it? And 1C?
Yes.
And 1C as well?
Well, 1C, we're proposing, I can deal today with some of the matters of context by way of explanation of the response that have been made in the past to those.
But will that be on a, if you like, a factual basis related to the questions asked rather than in respect to any jurisdictional argument?
Yes, I'm not seeking to raise any question about the Commission's power in relation to those matters. It's a matter of the appropriate exercise of discretion as to whether these directions are required. And as I said, we don't oppose the directions in 1A and B. In my submission, it's not necessary to provide a statement dealing with the matters in C. And I'll also have some things to say about D, but these are matters going to discretion, not to power.
Okay. And do you want to reserve your position in respect of any possible future argument about power?
Of course, any individual exercise of power has to be determined on its own merits. It can't be dealt with in a general way in the abstract.
Can you enlighten us as to what the meaning of process-related topics is in the correspondence?
Well, my understanding of that is that it's a question of how directly matters are related to the matters that are subject of the terms of reference. So it's a relevance assessment.
Okay.
Sorry,
As Longbottom. Sorry.
Oh, I was just going to illustrate that by reference to the matters to do with the PSPF, the framework for dealing with the classification of information. That's obviously not a matter that's directly relevant to the matters that are subject of the Commission's inquiry. So whether or not, if it was sought to exercise the compulsory powers to require production of information about that matter, would require an assessment of the relevance of the information to the matter that the Commission will investigate.
Does that satisfy you, Ms Longbottom?
Well, not entirely, Commissioner, in part because Order 1B is directed to the very issue that Ms Maud has just raised. We're seeking a signed statement from the officer who determined the final classification of 3 sample documents. So I'm not entirely clear, even in a specific sense, what the position of the Commonwealth is. Can I say this more generally, however? There are 2 propositions in the letter of the 16th of June. One deals with relevance, the other deals with, it would appear, the base power of the Royal Commission to issue directions with respect to its own processes under its incidental powers. This is a matter that affects the day-to-day working of those assisting the Commission in their interactions with the Commonwealth, because it is difficult in the face of protestations about defences, the Commonwealth's support of our vital work, to then have the Commonwealth say, well, look, we're not going to do what you ask to do, and in effect set its terms on which it does cooperate with us. And that is an issue that affects the day-to-day operation of the Royal Commission. So while we appreciate it's not a matter that can be dealt with in the abstract, we do think there is some importance in having clarity about the Commonwealth's position about compliance with directions you as commissioners issue with respect to your processes and procedures, and separately, that the Commonwealth will honour its commitment of supporting our vital work by, where we ask for particular things to be done, unless there is a valuable reason why it can't be, assisting us in the respect in which we ask, rather than having a back and forth on correspondence about these issues, which is a waste of all of our time and resources.
It's a bit difficult for us to make a ruling in the abstract, though, isn't it?
It is, but I understand Ms Maud to be saying in relate, I mean, if the PSPF is an example, 1B seems to squarely raise that. And if this is a matter...
I thought 1B was conceded by Ms Maud.
Well, that's what I'm a bit troubled by, because 1B does touch on the issue of the power to issue directions with respect to matters of classification. So that's why there is some lack of clarity in my head about precisely what the Commonwealth's position is. But yes, Commissioner, I accept it is difficult to rule in the abstract. But if this is to be an ongoing issue, it's a matter which ought appropriately be agitated sooner rather than later, and it would be a matter that I would have thought would require relief to be sought in the federal court.
Okay, well, at the moment we're dealing with 1A and 1B, which are conceded, so
yes,
well, I don't see that raises the issue unless something arises in 1C.
As I say, it just wasn't clear to me the basis of Ms Maud's submission that PSPF classification would be a matter in respect of which the Commonwealth would put in issue the capacity of commissioners to issue directions, given that that is in terms of what is sought by 1B. But Ms Maud may be able to clarify that issue.
Do you want to say anything else, Ms Maud?
It depends on the...
I didn't hear the answer.
Sorry, Commissioner, I thought there was someone else speaking. It depends. It's a context-specific consideration, and it's, in my submission, not appropriate to be dealt with in circumstances where here we're not opposing the specific directions that are sought. So if at a future point in time the Commission seeks to exercise its compulsory powers and the Commonwealth takes the view that that's not a valid exercise of the power, then that will be dealt with if and when it arises. It
might be of use to those assisting the Royal Commission, though, to have a bit clearer approach to it than simply labelling topics as process related.
Yes, I accept that. That's a general description. I accept that where information is sought about matters that might have a process character, but they are nonetheless relevant, for example, to findings that might be made about evidence of a particular witness or something like that, that there would be a sufficient connection of relevance for that.
Well, some explanation like that might be useful to be put into correspondence.
Yes, and my instructors are all here and have heard what the Commission has said about that, so we'll endeavour to be specific about those points. Yes.
Okay, shall we move on?
Yes, Commissioner. The only other thing I would note is this issue might arise in the context of a practice guideline we will be talking about during the course of this morning's procedural hearing, but we can deal with that as and when it arises. Commissioners, it might be helpful if you have the aid memoir in front of you. The first two topics that are identified as topics PH1 and PH2 may be conveniently addressed together. They concern, respectively, the classification of and correction to material produced to the Royal Commission by the Commonwealth. Those topics relate to draft directions 1A and 1B, as well as practice guideline 7. Now, I stand to be corrected, but it might be convenient to identify the ground as between the Commonwealth and the Commission to begin with. I understand that the Commonwealth does not put in issue draft directions 1A and 1B, but I might ask Ms. Maud to tell me if I'm wrong about that.
She said that already.
Yes, I just wanted to clarify, yes. So these issues, then it might be helpful then, Commissioner, to address these issues in terms of the practice guideline 7, which we will ask the Commonwealth to comment upon, but we do recommend that you commissioners make. Essentially, the practice guideline is directed to this matter. That is, the efficient conduct of hearings has been affected by the late notification of corrections to update witnesses' evidence, as well as what appears to be a shifting classification of documents that are produced by the Commonwealth. Now, that issue may be illustrated by just one example, which is the evidence of Captain Francis, who you might recall appeared during hearing block 9 on the 17th of May, 2023. Now, I might just step you through the chronology. I don't think it's necessary, but I can, if the Commonwealth requires me to, go to the particular documents. In short, on the 24th of April, a consolidated version of Captain Francis's statement was produced to the Royal Commission with a protected security classification. Now, as you will appreciate, the practical consequence of such a classification is that the evidence can't be published and its contents can't be replicated in the final report. That classification also has ramifications for how the information is held within the IT system operated by the Royal Commission. 2 days later, on the 26th of April, a declassified version of Captain Francis's statement was produced with redactions over specific portions of the statement that were identified as protected. Now, this, as I understand it, is the standard practice adopted by the Commonwealth with respect to statements. On the 15th of May, the Royal Commission sought particulars from the Commonwealth as to the basis for the redactions over the protected aspects of Captain Francis's statement. And then on the 16th of May, the Commonwealth stated that it relied upon earlier articulations of the basis of the protected security classifications, but also that it would provide a further redacted version of Captain Francis's statement shortly. That further redacted statement was provided on the 17th of May 2023, which was some 90 minutes before Captain Francis was to give evidence, together with a supplementary statement correcting discrepancies in his statement. Now, as you might appreciate, and I say this acknowledging the competing pressures that are upon the Commonwealth and the Royal Commission, or those assisting the Royal Commission with respect to hearings, the late delivery of a statement with further redactions, as well as a supplementary statement, which, as I will come to, corrected some discrepancies in his earlier statement, has a real impact on those who have carriage of evidence that is to be given during these hearing blocks. Now, what eventuated in relation to the discrepancies during the course of Captain Francis's evidence was that he informed you commissioners that around the time of submission of his statement, which was on the 21st of April, both he and his chief of staff thought that the numbers regarding a topic in his statement, that is unacceptable behaviour, was lower than expected. He indicated in his evidence that he alerted the Commonwealth team of that submission before a process was undertaken to clarify whether or not there was, in point of fact, a discrepancy in the numbers, but that the discovery that the original statement admitted reference to several unacceptable behaviour complaints was made earlier than the night before he was to give evidence, which led to the revision of the supplementary statement on the day he appeared. That is illustrative, not just of the reason why we are seeking those orders, but also why we are urging you as commissioners to make practice guideline 7. Now, as I understand, but again, Ms. Maud may clarify the position in relation to the practice guideline. The first 2 paragraphs, which are directed to a process by which corrections or amendments to evidence are notified, just to ensure there is some rigour in the process, isn't controversial, but I might pause to let Ms. Maud give an opportunity to respond if I am incorrect about that.
Can I just ask about line 2 of paragraph 2?
You may.
Specified by paragraph looks like open brackets, close brackets. Should there be a 1 in there?
There should be a 1, Commissioner, yes.
Thanks. Yes, Ms. Maud?
Commissioner, just pardon me one moment. I understand we've been given a further version of the practice guideline this morning, and I just want to clarify that there's no changes to these parts that have changed.
Sure, take your time.
Commissioners, in substance, the proposed practice guidelines are not opposed, but we have some suggested changes to the drafting to seek to clarify what's required by those paragraphs. So in paragraph 1A, in following the end of line 4, so at the moment line 4 reads clarification in brackets, including because it has been incorrectly classified in accordance with the protective security policy framework. And the Commonwealth would suggest after the word in accordance at the end of line 4, the insertion of the words or in brackets or its classification has changed, close brackets, with the protective security policy framework. And that's just to acknowledge that classification of documents is a point in time, requires a point in time analysis. So it requires consideration of the necessary classification of the document at the particular time. So it's not necessarily that a document has been incorrectly classified. It may just be that its classification has changed.
Sure.
So that's the first proposed change.
Any opposition to that? Ms. Longbottom?
No, Commissioner Douglas.
Thank you.
And then the second suggested change is the addition of some words in the paragraph following subparagraph B, 1B. So at the end of the third line, after the words 3 clear days, the Commonwealth suggests the addition in brackets of the words, assuming that the error or change has been identified by that time.
Can you just say that again, assuming that the error?
Or change has been identified by that time. But obviously, we can't deal with errors that haven't been identified. And as I understand it, subparagraph 2 is intended to deal with that. So it may be that within the 3 clear days prior to the hearing, an issue might be identified and it will still need to be corrected at that point. And so then paragraph 2 would be operable in that circumstance.
Any submission about that, Ms. Longbottom?
No, that's fine, Commissioner, and Ms Moore correctly identifies that 2A is effectively intended to capture a circumstance in which less than 3 clear days before an individual gives evidence, an error or correction is identified.
Okay, thanks. So paragraph 1 and 2. Any other amendments you wish to suggest, Ms. Moore, to paragraph 2?
No, Commissioner, thank you.
Okay.
The second issue, Commissioner Douglas, which I think is more controversial from the perspective of the Commonwealth, is this issue of classification of documents and what we have experienced in terms of shifting classification of documents. Now, I might address this issue, if I could, by reference to the PSPF guidelines. I understand there is a copy. Deloitte does have a copy. If they could please turn to paragraph 24 to 26 of that document and highlight those paragraphs.
What's the identifier? I'm trying to get it from my own computer too.
I don't think it does have an identifier. I apologise, Commissioner Douglas. Hopefully you can see.
Do we have a hard copy of it?
Yes, we can arrange to get you a hard copy right now, Commissioner Douglas.
All right.
Is it in the material that we've received already, Ms. Longbottom?
It's not, unfortunately, Commissioner Caldas.
That's fine. Thank you.
It's a late addition. But look, in substance, we, as a staff at the Royal Commission, accept that we are not experts in terms of the process of classification of documents. That is a matter in respect of which the Commonwealth clearly is. But this document that I've just brought up on the screen is a policy framework by which those decisions have made. And as paragraphs 24 and 26 make explicit, the Commonwealth acknowledges the need to, in effect, not over-classify information, because amongst other matters that can result in access to and those are matters that really are material to in terms of the day-to-day operation of this Royal Commission, specifically with respect to hearings. And it has been the experience of those assisting the Royal Commission, including in the case of Captain Francis, that there is shifting classifications, which has a real practical impact upon how we do our work, because, as I've identified, protected information can't be displayed. It can't be adduced into evidence during the hearing. It also needs to be held on a different IT system. So it is an issue that is very onerous in terms of the effective interrogation of issues. Now, to address that, we propose a process of certification of documents, really in order to ensure that there is accountability with respect to classification decisions. You may hear that from the perspective of the Commonwealth, this is an unnecessary administrative overlay. We say it's not. all this practice guideline proposes is that at the time an individual within the Commonwealth classifies a document, they fill out a form that certifies that they have considered and appropriately classified it. We hope that rigour of this type may avoid situations with which we have been faced previously where there is shifting classifications. That's all
So
I
you're
have to say.
trying to- So you're trying to introduce an element of accountability for the classification at an early
Precisely.
stage.
Yeah,
Okay.
precisely, Commissioner Douglas. It reflects, you know, a certificate that solicitors give when they sign, when a pleading is delivered. It's just directed to ensuring accountability in light of the acknowledgement in the Commonwealth's own policy that overclassification is a risk and a risk that needs to be managed.
Ms. Moore, do you wish to address that now?
Yes, Commissioners. So just to start with paragraph 3 in its entirety, the Commonwealth is not concerned with the proposed guidelines 3A and B. Those matters reflect the current practice that the Commonwealth implements, so we don't have any concern with those. The only suggestion that I would make in relation to paragraph 3A is perhaps the addition of a reference to the specific section of the Royal Commissions Act. So as I understand it, it's we're talking here about notices to give information under section 2, 3, capital C of the Act. So it
Can
might
you
be.
describe that section again, please?
Yes, Commissioner. Subsection 2 is the provision that deals with the Commission's powers to summon witnesses and take evidence.
Was that section 2 or section 3?
Section 2, subsection 3, capital C.
Thanks. Any objection to that, Ms. Longbottom?
No, Commissioner.
So the Commonwealth is not troubled by paragraphs B Roman 1 and B Roman 2, because as I said, those reflect the current practices in any event. The issue that we have is with
There are
Recording
words. There are two superfluous words in paragraph 3B Roman 2 in the first line. After
Yes.
that has, the has can be deleted, I think.
Yes. Yes, quite right, Commissioner.
Then Roman 3.
And in relation to Roman 3, in my submission, this is the overlay of an unnecessary administrative burden that would have, in my submission, a real question as to what the status is of the certificate. Well, what we understand would be required is that when the Commonwealth is assembling information to respond to a notice to give information, and of course that information often requires consultation with a number of different sections within defence in particular. For example, often it requires consultation with the Defence's people group and with the different services, Army, Navy, Air Force, and often sometimes with Joint Health Command. So consultation is required with all of these agencies. Information is then collated by the task force that has the primary responsibility for assisting the work of the Commission. And those people then assemble the information that's been provided by the different parts of different agencies and prepare the response to the notice. If this certificate mechanism was to be implemented, potentially there would be a need for multiple different people to certify that different aspects of the information that has been collated has been appropriately classified. And because the framework under the PSPF imposes on the originator of a document the obligation both to initially classify the document and to make any subsequent variation or decision to declassify the document, that onus is on the originator. So in each case, it's that person who has to be consulted to determine whether particular information should retain its existing security classification or whether that can be revised. So in my submission, that consultation requirement and the need then to have either one person or multiple people provide a certificate certifying that the document's classification is appropriate. It is an onerous burden on when the resources of the Commonwealth are already stretched in dealing with the work of the Commission, and the Commission has already heard about that in terms of difficulties complying with short timeframes for responding to notices. In my submission, there's just not justification at this point in time for the imposition of a mechanism of this kind.
But we have had pretty regular experience of claims for particular classifications being withdrawn at the last minute, which is a bit of a nuisance, quite frankly.
Yes, I appreciate that. Obviously, I know much less about the workings and the day-to-day issues that have arisen in relation to the Commission than everyone else here. But my understanding is that there have been about 10 requests in recent times for clarification of particular security classifications, and in each case, those requests for information have been dealt with by correspondence. So where issues have been raised about the basis for a particular classification, that information has been provided by the Commonwealth. It has arisen, we've heard already, in the context of Captain Francis's evidence, but in my submission, I accept that it's a difficulty and it's unfortunate when these issues do arise because they make the day-to-day work of the Commission more difficult. But these are complex issues requiring, as I said, consultation with numerous different people. And so to impose a mechanism of this kind on the Commonwealth, it's in my submission just going to unnecessarily add to the burden of the work of responding to the notices that the Commission issues.
Anything in response to this one?
Yes, please, Commissioner. May I say two things? Firstly, the issue shouldn't have to be raised by the Royal Commission for the question of classification to be seriously considered. In our submission, what we're asking for isn't an administrative overlay. We are simply requesting that what should already be done, that is, serious consideration of the question of classification so that material isn't overclassified, is done and documented at the time the notices are produced. Now, if there are 4 or 5 decision makers in relation to a particular notice, all it requires is for each of those decision makers, when they make the classification decision, to certify that they have considered the issue of whether or not particular classification is apt. The difficulties with that not occurring at the time are, I would say, neatly illustrated by the evidence of Captain Francis, who you might recall indicated that when he drafted his statement, he did so with a view to it not having a protected classification in the first case. And as things eventuated, the protected classification or aspects of it shifted. So we say it's not a inapt administrative overlay. It is a measure of accountability that ought, consistent with what the PSPF requires, be done at the time classification occurs.
I'm sorry to raise an additional issue after my friend has already started her response. But can I just say one other thing about post 3B3? And that is that it contemplates that a solicitor representing the Commonwealth would provide the certificate
Or the person who made the final determination. That's
Yes.
classification.
But in my submission, it's not appropriate to have the solicitor giving a classification of this kind, because under the PSPF, as I've said, it's the originator of the document that has the responsibility of both making the initial classification and any subsequent decision. So a solicitor is only ever going to be relying on the advice that they're given by the originator of the document. So in my submission, there shouldn't be a reference there to the solicitor representing the Commonwealth. If there is to be a mechanism of this kind, there shouldn't be, but if there was to be, the only person who can properly give the certificate is the person who, under the PSPF framework themselves, is responsible for the classification decision.
Would you like to respond to that, Ms. Longbottom?
I can't answer. I don't have the knowledge to identify whether or not a solicitor will ever be the relevant person in terms of classification. Perhaps the signed statements we receive in response to the directions will address that issue. Certainly, the annexure doesn't mandate that it is the legal practitioner. It can be the relevant person. Can I say one thing, though, that is somewhat troubling about the submissions that have been advanced is that all we're asking for is certification that the classification process has been conducted appropriately. It's difficult to understand why that is problematic if, as one would expect to be the case, that has occurred. So we're troubled by why there is a contest about this in the first place. But that's all I have to say about it, Commissioner.
I suppose your submission is that the legal practitioner isn't classifying it, it's just saying that it seems to have been appropriately classified.
That's so, Commissioner. And if a legal practitioner isn't in a position to do that, then the other relevant person can. The practice guideline doesn't mandate that it happen by the certificate be provided by a relevant. But the very purpose we seek draft direction 1B is to illuminate for us and the Commission the purpose, the way in which this occurs, because at the moment we are in the dark about it. So we don't know what role, if any, solicitors play with respect to it.
Yes, thank you. Anything else, Ms. Moore? Nothing else, Ms. Moore?
Pardon me, Commissioners, I'm just seeking some instructions in relation to one additional matter. Could I just have one moment?
Okay.
Commissioners, I said earlier that we were content with paragraphs 1, Roman 1 and 2 of 3B, but I'm just advised that there is...
Can you start again, please, Ms. Moore? I was talking to one of our colleagues.
Of course. I said at the outset that we were not troubled by paragraphs 3B, Roman 1 and 2 of this proposed practice guideline. Excuse me, but an issue has just been brought to my attention in relation to paragraph Roman 2, and that is that where a classification applies to the whole of a document and not just part of it, then of course it won't be possible to produce a declassified version of the document.
Mm.
So I instructed that the words "where possible" should be inserted at the commencement of that subparagraph.
Any submission about that, Ms. Longbottom?
We have no difficulty with that, Commissioner. We should just say this. Obviously, it is within your discretion, Commissioners, about whether or not you make this practice guideline. but this is a recommendation that we at least make that may seize on the issue Ms. Maud has raised about the outset about procedural directions with respect to matters going to classification of documents. So it will be important to understand whether or not the Commonwealth puts in issue your power to make a guideline of this type.
I don't think that's been argued.
No, I just wanted to clarify, given the issue raised at the outset about PSPF classification being an example of an issue that the Commonwealth might say is outside your powers.
Okay. As part of the submissions in this directions hearing, there has been some argument about a proposed draft practice guideline number 7 relating to classification of documents and corrections or amendments to evidence. Paragraphs 1 and 2 have been the subject of some helpful submissions made by the Commonwealth about wording, which are not opposed. Paragraph 3B, Roman 3, relates to the production of a classification certificate, in effect designed to try to make sure that classification decisions have been made accurately at an earlier stage than has sometimes occurred otherwise in the Royal Commission hearings. An example of changes in classification related to the evidence of a Mr. Francis, and it has been apparent to us in hearings at the Royal Commission that late changes of this nature can be an impediment to the regular conduct of our hearings. So we think that it is important that these decisions are made carefully at an earlier stage than may have occurred in some cases before us. The classification certificate proposed is one, in effect, designed to enhance the rigour of the making of the classification. A submission was made by the Commonwealth that it was inappropriate to have the classification certificate signed by a solicitor representing the Commonwealth, unless that person, no doubt, was the relevant person making the decision. It seems appropriate to us that the person who made the final determination as to the document's classification may be the more appropriate person to certify to that effect. The effect of the current proposed draft does not necessarily impede that, because if a legal practitioner does certify it, it is not a case that the legal practitioner is actually classifying the document, but simply saying that it's been appropriately classified. But having a regard to what we've been told is the practice by the Commonwealth, it seems appropriate that the responsibility lie where the Act places it, with the person who made the final determination as to the document's classification. Therefore, with some other helpful additions which are not opposed, suggested by the Commonwealth, I would strike out the words in the proposed practice direction 3B Roman 3, either a solicitor representing the Commonwealth, or so that it now reads a classification certificate substantially in the form of Annexure 1, signed by the person who made the final determination as to the document's classification and declassification. And that would have the consequence that the name of legal practitioner would be deleted in the classification certificate proposed. So delete the words of legal practitioner or other, well, sorry, just delete the words legal practitioner or other and leave the word of in. Other than that, I would propose to make the guideline in the form suggested. Certainly to agree on.
I also agree.
Yes, what's the next? Longbottom?
Topics PH3 and PH4 may be dealt with together. They concern confidentiality claims over suicide-related incident information and notices seeking information relating to deaths by suicide. Those sessions do, however, need to be dealt with in a closed session. So we may leave those two in your hands, Commissioners, but it may be convenient to leave those to the end and instead then turn to topic PH6, which is on page...
Thanks, we'll do that.
Thank you, Commissioner. That topic is on page 4 of the aid memoir. In essence, it concerns compliance with the document management protocol. Materially, that protocol requires compliance with notices produced to the Royal Commission, and the protocol, among other matters, requires documents to be produced in a format that is text searchable and with metadata that states the paragraph of the relevant notice the document relates to. Now, as I understand it, in excess of 200,000 documents have been produced by Commonwealth entities to the Royal Commission. The majority of these documents are coded in accordance with the document management protocol, but there are around 80,000 documents that don't in their inherent form have that compliance. There are two critical issues with respect to compliance with the document management protocol. The first is the Commonwealth is often delayed in producing documents to the Commission in what's called the DMP format, and that delay creates significant issues in our ability to prepare for hearings. Secondly, where documents aren't coded in accordance with the document management protocol and are not text searchable, this hampers the ability of the Commission to identify and analyse the breadth of material that has been produced. And it is a significant issue in terms of the Commission or the staff assisting the Commission being able to conduct its important work in the timeframes for the provision of a report. Draft Direction 1C, against that background, seeks an explanation from the Commonwealth as to the context and reasons why there has been a failure to comply with the document management protocol, and critically from our perspective in terms of looking forward with this issue, an explanation as to the extent to which the Commonwealth considers it will be unable to comply with what the protocol stipulates moving forward.
Is the main problem, apart from delay, the highlighting, which results in it not being text searchable?
Precisely. So the issue is documents that are produced don't comply with the protocol, so they're not text searchable. Also, they don't have the metadata that enables the relevant aspects of the notice to be matched to the documents to which it relates. So it affects our capacity to analyse and distill the information that is produced.
So is it effectively like a PDF without any metadata attached to it and without having text searchable qualities? All of the metadata.
As I understand it, Commissioner, it varies. In some cases, there will be some metadata, but not all the metadata. I don't think there is a single position with respect to each instance of non-compliance, but the non-compliance is of one of the types that I have mentioned and affects our capacity to utilise the data produced.
So at the moment, all you want is a context and an explanation as to the failure to comply.
Precise, but also, Commissioner, an explanation is the extent to which the Commonwealth considers this will be an issue moving forward. Again, it comes back to this issue of accountability and endeavouring to ensure, noting the pressures that all of us are under, there is a rigour in the process so that you can undertake the very necessary work you need to produce a report in the time stipulated by the government.
Yes, Ms Maud?
Thank you, Commissioners. The Commonwealth submits that paragraph 1C of the proposed directions is not appropriate. In terms of explanation as to why there are some instances where documents are produced in a format where they are not OCR'd, and the second issue that's raised is where documents are produced without the specific paragraph of the notice pursuant to which they're being produced being identified in the Excel spreadsheet. Those issues have to be considered in the context of the overall task that the Commonwealth is undertaking. The number of notices that have been issued, even since 30th of April this year, there are 82 notices. The volume of work is significant. The Commonwealth prioritises provision of timely responses to the notices. So there are instances where, in order to provide the information in a timely way, it may be provided where there are minor issues with the DMP. Those issues can arise in circumstances.
It's not minor if you can't if you can't do a text search of it.
No, I accept that is certainly creates difficulties in using the documents. But where those issues arise, it's sometimes because at the point where the documents were entered into Ringtail, they were not entered in the OCR format. And so in order to comply with the timelines of the notice, it's not necessarily possible always to go back and check each document to make sure that it's in the right format. The other issue that arises with OCR is that where hard copy documents have been scanned to produce a scanned version of the document, the quality of the original document can impact the OCR process, and so impacts on the quality of the documents that are ultimately produced. So
I'm familiar with that, but all this really seeks is a rather more formal explanation than has been provided so far, and in effect a proposal as to how it can be dealt with in the future.
Well, the short answer is that everybody is trying to do the best they can in very tight timeframes, and so to the extent that we've prioritised producing documents by the time requested, where sometimes that means that aspects of compliance with the DMP has not been possible, then the prioritisation has meant we've produced them in that format. To require strict compliance with all aspects of the DMP will raise the prospect that we won't be able to produce documents within the timeframes that are specified in the notices.
An alternative may be, though, to produce them as soon as you can and then undertake to OCR them and provide the OCR versions later. That's the sort of thing you're being asked to talk about, a proposal to make the task feasible.
But with respect, Commissioner, that's what we already do. The documents are produced, and then if there is any issues with compliance with the DMP, where possible, those are rectified at a later date. But we prioritise providing the documents in a timely way and dealing with the DMP issues afterwards where that's possible. So that is already what is done.
All right. Anything else you want to say?
Yes, in relation to the second issue that's raised, which is in relation to the Excel index that accompanies each of documents, and an issue has been raised about the specific paragraph or category of the notice not being identified in the production. I just note that paragraph 10.1 of the DMP requires this information to be provided where available. So it's not necessarily an absolute duty that be provided in every instance. It's true that there are instances where that information has not been captured in the production, but where that issues as to which category within a notice documents relate to have been raised with the Commonwealth has provided that information as quickly as it can. Where possible going forward, the Commonwealth will endeavour to include that information in its Excel document at the time of producing information. And with respect, other than giving that indication, it's difficult to see what assistance the Commission is going to have by any further explanation. These are all ultimately resourcing and time issues. And we don't have a magic wand to have the number of people that would be necessary to both comply with the time frame and produce the documents with all of the information in every instance required by the DMP. It's just a practical issue.
It's not a practical issue to provide a context and explanation, which may perhaps just be something in writing, elaborating what you've been saying.
Yes, there has been significant correspondence about these issues, and that explanation in my submission has been provided. But the Commonwealth shouldn't be required to revisit issues that have already been addressed in correspondence and which I've sought to explain today, when that's inevitably going to distract us from complying with all the other work of assisting the Commission that the Commonwealth is undertaking.
Anything else?
No, Commissioner. Thank you.
Ms. Longbottom?
Yes, Commissioner, can I say two things? The intent of the direction is to arm us with the information so that we can look at the document management protocol, and if there are ways in which we can constructively work with the Commonwealth to address this issue moving forward, we can. But that step is
Ms. Maud says you've in effect been told what the problems are, and that they're attempting to fix some of the documents that they can fix, or provide the information they can fix at a later time. Do you want to respond to that?
Well, in relation to the fixing of documents, I understand in relation to the issue of the Excel spreadsheet and the metadata, we're still in a position where that hasn't happened for the vast majority of documents that have been produced. But putting that to one side, if, as Ms. Maud says, an explanation has been provided in various pieces of correspondence, it shouldn't be onerous for that simply to be identified in a short letter to the solicitors assisting the Royal Commission, so we can look at our end as to whether or not there's anything we can do, including in terms of modifications to the DMP to address this issue moving forward. That's all I have to say.
All right. There is opposition to the proposed direction 1C, requiring the Commonwealth to provide context and an explanation about its failure to comply with the document management protocol and the extent to which the Commonwealth considers it will be unable to comply with the DMP in the future. There have been problems with delay, but perhaps also more significantly with the production of documents that are not in a text searchable format and which do not contain the metadata sought by the existing document management protocol. Ms. Maud says that explanations for those issues have been provided in correspondence. The direction sought merely seeks a context and explanation of the problems, and as Ms. Longbottom says, it may assist counsel assisting and the Office of Solicitors assisting to look at the document management protocol to consider whether it should be changed. And it will be useful too for us to have something directly addressing the potential inability of the Commonwealth to comply with the document management protocol in the future. So we think that this direction in itself is not overly burdensome and should be made and complied with. Agree?
I agree.
I also agree.
Thank you. Does that take us to 7, PH 7?
It does, Commissioner Douglas. That topic relates to proposed direction 1D and concerns the Defence Strategic Review, which the Commonwealth sought production of by the notice identified in subparagraph 1D of the draft directions. Now, we understand the document will not be produced because there is a public interest immunity claim made in respect of its contents. In correspondence, the Commonwealth sent the Commission on the 5th of June 2023, which is document number TB53 in the tender list. The Commonwealth stated that it anticipated relying on affidavit evidence in support of that claim. And then we received a subsequent letter on the 16th of June 2023 indicating, and that document is tender bundle number 55, indicating that in light of an agreement we've reached with the Commonwealth that there be an inspection rather than production of the document, provision of the evidence and submissions in support be deferred until after any inspection has taken place. In our submission, given the fact of the notice to produce, there ought to be submissions and evidence in support of the public interest immunity claim. We don't have a strong view as to when that submissions and evidence should be provided to the Royal Commission. We simply ask for directions that it occur.
You want to specify a date by which it should be done? Or?
Well, the draft directions seek it by the 7th of July 2023.
That's right. Yes.
But if the Commonwealth says that it needs longer, we won't strongly resist that.
Okay. Ms. Maud,
Thank you, Commissioners. The Commonwealth's position is that following inspection of this document might be formed within the Commission that the document is of only marginal relevance. And so in circumstances where it's clearly against the public interest for it to be disclosed for a number of reasons, but most obviously because it is a document that
I don't think we want to enter into a discussion about whether it's relevant or not at the moment, do we? We just want to focus on proceeding towards a hearing about the public interest immunity claim.
I'm not necessarily suggesting, not suggesting you need to determine the relevance. What I'm saying is in terms of the process that the Commission adopts, it may be that following inspection, the view may be formed that the document is obviously subject to a valid PII claim and the notice would then be withdrawn. In that circumstance, it would not be necessary for the Commonwealth, to put on evidence to substantiate the PII claim. PII obviously has a two-part process. It requires identification of the public interest that is against disclosure of the documents. This particular document, there are three aspects of that. It is a document that was the subject of consideration by a committee of cabinet. So it invokes the obvious class category of a cabinet document, and that is an overwhelmingly strong public interest against disclosure. And the cases make clear that it's very hard to imagine a document in a civil proceeding that would be so relevant that it would weigh against that important public interest. So all I'm saying is that following inspection of the document, members of the Commission may be satisfied that its relevance is marginal and therefore it is obviously going to be subject to a valid claim as PII, and the notice could at that point be withdrawn rather than requiring the Commonwealth to put on evidence to substantiate the PII.
Would you submit then that the direction should be that there be an inspection on behalf of the Commission of the document to determine whether or not it should withdraw the notice?
Well, in my submission, Commissioner, it's not necessarily that there be a direction. Parties have already been in discussions as to the appropriate arrangements for inspection. The Commonwealth has set out a detailed proposal in its letter of 23 June. I don't think we've received an indication from the officers of the solicitors assisting as to whether those terms are acceptable. But assuming that they are, that inspection can take place without the need for any direction. And status of the notice can then be assessed by the Commission. The Commonwealth's own view is that the document is of, at best, marginal relevance to the matters the subject of the Commission's investigation. And in circumstances, as I said, where it is obvious on its face that it is a cabinet document, it's unnecessary if the Commission accepts that view of relevance to put the Commonwealth to the time and expense of preparing affidavits addressing all of the grounds, excuse me, of the PRI claims, which, as I said, is not only cabinet but also national security and interference with foreign relations, potentially requiring statements from a number of different people, and having regard to the fact that the nature of this document means it's been very, excuse me, tightly held within government. There are only a very small number of people at a very senior level who are able to speak to the document. So requiring statements.
So you're in effect submitting that we don't need to make this direction at this stage.
Yes, Commissioners.
Ms.
Allow the
Longbottom?
agreement to take place and the issue can be revisited.
Commissioner Douglas.
That makes sense apparently to me, Ms. Longbottom.
Well, the difficulty with it is this, Commissioner Douglas, the notice to produce seeks production of the entire document and we're only inspecting part. So we won't be in any, we won't see the balance of the document and therefore be in a position to reach an independent view as to the public interest immunity claim.
I see.
And
You want
if it is self-evident that the claim should be upheld, given the fact of the notice, we don't see why there is a huge difficulty in providing submissions and evidence in support.
Commissioners, can I just address that? My understanding is that there has already been acceptance, at least by OSA, that only part of the document is relevant to the Commission's terms of reference. So although the notice might seek production of the whole document, I don't understand the position to be that the whole of the document is responsive to the notice because it's only part of it is relevant. So what has been discussed between the solicitors is that there'll be inspection of only the relevant parts of the document. So we had understood that the scope of the notice had already been narrowed in effect.
Can you?
Instructions on that, Commissioner Douglas. My understanding, Commissioner Douglas, is that we haven't accepted that only part of the document is relevant, but we have accepted that we will only inspect particular parts of it. So the notice on its face requires production of the entire document.
We're inclined to adjourn this aspect of the application till after the inspection of the document.
Certainly, Commissioner.
Okay.
Great.
That leaves a couple of matters, doesn't it?
Okay.
PH8.
Yes.
Is PH8 reflected in the order?
It's not, Commissioner Douglas. All we seek is one of the documents that we tendered was a letter that sets out qualifications to a report that was put in evidence in March of 2022 and in respect of which a non-publication direction was made. If I can step this out, that might be most helpful to you. A non-publication order was made in respect of what's called the ACSHQ report because of concerns raised by the CEO of that organisation about limitations in the analysis in the report. We simply seek that you lift the non-publication order on the basis that we have today tendered the accompanying letter from the CEO of the organisation so that the two documents can be read together and the report, which is otherwise we consider important to the work of the Royal Commission be not just received but utilised in your work.
Does the Commonwealth have a view on this, Ms Maud?
It's not opposed, Commissioners.
Thank you. Well, we will lift that non-publication direction presently in place in respect of the ACS-QHC report. Perhaps that should be reflected in the order made on this directions hearing.
We can attend to that, Commissioner.
Okay, thanks. Agree?
Yes, I agree.
I agree.
So,
That leaves the tabs 3 and 4, doesn't it?
It does, yes.
Right.
And so we would require a closed hearing to deal with those issues, Commissioners.
Yes, we're happy to do that. Our technical man has just gone off. So
I understand if we're going to shift to a closed hearing, we should have a break briefly so that technical issues can be attended to.
Certainly, thank you, Commissioner Caldas.
Half an hour.
I think
Commissioners, pardon me, before we break, can I just indicate at the outset that neither Ms Brinker nor I have any active security clearance at present. So I don't know what documents my friends are proposing to go to, but I just note that we're not able to view or have regard to any protected or other classified.
do any of your solicitors have that clearance?
Yes, all of the instructing solicitor team do.
Ms. Maud, it may not be an issue, and I won't preempt what Ms. Longbottom might say, but the topics, as I understand them to be discussed in 3 and 4, are not necessarily related to classified information. It's more about sensitivities of discussing publicly suicides and suicidality in a trauma-informed way. Ms. Longbottom might correct me.
No, well, no, that's substantially correct, Commissioner Caldas. To the extent to which there will be a discussion about protected classification material, it'll be the fact of that classification, not the detail of it. So we don't apprehend that'll be a substantive difficulty for the conduct of the closed hearing.
If the Commission pleases.
Thank you.
Thank you. We'll just adjourn shortly then. Thank you.
I should add,
Sorry.
Commissioner, our understanding is that it should only take about 10 minutes to put in place the arrangements for the closed hearing.
Thank you. We'll adjourn briefly then. Thank you.
All right. The Royal Commission into Defence and Veteran Suicide is now adjourned.